docket this morning, which is DREGGORS versus WASSAU. Whenever you're ready, Mr. Egan.
Yeah, please, the court. My name is Thomas Egan. I'm the attorney for the appellant. Before I begin my argument, I just want a house cleaning matter. In this case, as this court's aware, this court earlier dispensed with oral argument and subsequently, upon a motion for reconsideration, reset oral argument. There were two motions for reconsideration filed. One was filed by a non-party, Mr. Spangler, who had not filed a brief or appeared in this case, and I noticed Mr. Monsbach is here, who filed that motion. I don't know whether he's going to participate in oral argument or he intends to. That's right. I think
he said no. So,
all right. I think the filing a motion for reconsideration by a non-party is.
Do you want to start your argument?
I'll start my argument. If I may, as this court's aware, this is a tied-up piece of litigation going back all the way to 1991 in the Workers' Comp Court. It's been in 6 or 7.
Why don't we concentrate on the defamation?
I'll concentrate. The defamation is not as one final lawsuit that's still pending. As this court's aware, these cases, including the defamation cases, were all tied up and consolidated with a number of other cases. And then in a matter of a month or so, Judge Thorpe first entered an order of summary judgment as to a companion case, Faith Horn and Keating. A couple of weeks later, she entered the same judgment as to my client's case, both of which have been on appeal. And this is the third case that followed. The case, the court has before it the judge's order. I just want to address the judge's order because it's a motion for summary judgment. It has some interesting and particular procedural turns, the first of which is there was no answer to the complaint, and there was a motion for summary judgment that was filed bare of supporting affidavits. It was simply a motion for summary judgment tacked on. There was nothing filed by WASSAU Insurance to the effect that it did not authorize, or he was not an agent, or nor was he acting on behalf of WASSAU. The judge nonetheless ruled in her order that there was no evidence that WASSAU directed or authorized Spangler to make statements, and the alleged defamatory statements were not necessary or incidental to Spangler's representation.
We know about the relationship of the attorney to the corporation. The question to me becomes, in the discharge of his duties, was the creation of an interview or creation of a television opportunity part of the duties as a lawyer in a workers' comp case?
Judge Thompson, you're probably a little bit older than I am, but not by much. When I started practicing law, lawyers did not appear on television.
Be that as it may.
No, but in recent years, suddenly lawyers become spokesmen, and litigation is actually.
But can you help me? Was that part of his duties dealing with the workers' comp?
Well, when he appeared on television and made those statements, there was litigation ongoing. It was addressed to the public and anybody who cared to hear it. Statements were made about the merits of claims in which he was involved, and he made those statements accusing these people of engineering the greatest fraud in workers' comp history.
Suppose he had hit one of the parties while on TV. Would you argue that the corporation should be liable for his discharge of his duties as a lawyer in the case?
That would be exceptional, because there's a standard rule of law that when it comes to criminal actions, corporations are not liable, at least not by vicarious liability, for the criminal actions of their employees.
So would you agree with me, there are some things that a lawyer can do in a case
Absolutely.
that are not reflective of his relationship with the
Absolutely.
client?
But one of the
So my question to you again is, what in this case shows that he was working for the client at the time the statements were made?
Well, this is the issue. This is a factual issue. When he appeared on television, he appeared on behalf of WASSAU Insurance. He was identified as a counsel for the insurance carrier. He spoke about the case and about these individuals. He used videotapes that were surreptitious videotapes that were prepared by WASSAU Insurance, and those were provided to the.
So you're arguing it was incidental to his work to do these kinds of things?
Absolutely. I
And that a summary judgment at this point is premature, I would guess that's your argument.
There's another interesting aspect of this, and I think this goes back to the reason why they did not file a supporting affidavit. Obviously, a lawyer who files a motion for summary judgment is very first inclination is to get an affidavit. You have to dispose of the factual issues. You have to prove to the court that there's no factual issues to be resolved, and basically put the question to the test. Was he acting as an agent of the corporation? Was he directed, authorized? Was it incidental to his representation? All those kinds of things. An affidavit to the effect that I am a Joe Blow, representative of this corporation, I did not authorize, direct, I did not agree to, we did not pay for it. Something like that would have disposed on it and put us at our task. The problem with all that is that during the course of the case, discovery was attempted as to the issues about whether or not they were aware of this, whether or not he was even paid to appear on television.
Can a lawyer's opinion be used to hold his client liable if it's the lawyer's comments?
Yes.
Based on the lawyer's experience,
If
or
it's-
perhaps the lawyer's desire to be on TV?
If it's defamatory and slanderous, it can. Unfortunately, the lawyers and spokespeople act for corporations and say defamatory.
Doesn't the law hold that if it's purely opinion, then it's not actionable against the client?
It does, but if it's not opinion, and this was not opinion, he made various factual statements, most of which were absolutely false. The one that this is the largest fraud in Florida history, as this court's aware, the Dreggors received $0 at that time. He said that the court relied on the false testimony of the Dreggors, when in fact, and it's part of the record, what Judge Hawk relied on. There's 8 doctors, all of whom testified since 1991. This guy had been diagnosed as totally disabled, and they were all in the employ of WASSAU Insurance, and that's what the court relied on. Judges don't make decisions about incompetence of people based on the testimony of the wife. He represented that, but for the perjury of these people, this award would never have been made. Those are statements that he suggests he knows something, and he really doesn't. They're questions of fact that he makes statements about, and they're false. They were done to harm and reflect very badly on the Dreggors. And the very worst part about it is, at that time there was ongoing litigation between the Dreggors, their counsel, WASSAU, and WASSAU's counsel. And as you know, in those kinds of litigations, money's involved and negotiations involved. This is just another way of negotiating. It's a bit of hardball litigation. It's a rough form of litigation, but it certainly puts the Dreggors and their counsel back on their heels. These kinds of statements are made.
Let me go back to the discovery issue. I'm guessing, and maybe I just missed this and should know it from the record, but did you file a motion to compel? And was there a ruling from the trial judge that did not allow you to get to billing records and other records?
That's right.
Okay.
There was a ruling by the judge that we could not.
I'm not aware of any basis that you would have had to have appealed that as an interlocutory order, but couldn't you have challenged that in final appeal, that interlocutory ruling on discovery?
That was basically, we were not permitted to do any discovery about time or communications between the attorney.
But you didn't raise that as an issue in appeal? On appeal.
No, okay. We didn't. No, we didn't, because the rule has always been that if someone takes a privilege, you cannot benefit from the privilege and then argue a point that where you have concealed on the basis of privilege. The so-called sword and shield doctrine. This was an issue, to be frank, this was a surprising ruling by the court. that we had presented no evidence. The truth is, and I showed this in my brief, all these questions of agency, was there an apparent agency relationship between Spangler and Wausau? The answer is yes. He appeared on television. It was a matter incidental to his representation. He represented Wausau in this litigation. He brought with him videos, played the videos, spoke in a very derogatory, negative manner about these people. He didn't tell the public, oh, by the way, we've been in court 4 times with these people and lost every time, that I had a chance to put all of this on evidence in trial, and I lost every time we did it. He didn't reveal to them that this man had been diagnosed by 8 or 9 people as being totally incompetent, and all of these people were paid for by Wausau. Was that incidental to his representation? Absolutely. Question is, it's not just whether it's necessary, incidental. Did he act with the authority, the approval? Did Wausau pay him to go on? Did they know he was going on? We don't know that because that's attorney-client privilege. But that's not our burden.
It's not an issue on appeal, but I'm having a hard time with the concept that a billing record contains attorney-client privilege. I mean, generally they don't, and there might be a basis for the trial judge to hold an in-camera inspection to determine whether their attorney-client confidence is on the billing records, but, it's a general rule, but that's not an issue.
No, that's what, we didn't raise it on appeal. Judge Thorpe, this was kind of a surprise because we actually did not have argument on this motion before the trial court. After she disposed of the 924 cases, she then entered this order. And basically, this order really recants the argument made.
Are you saying that there was no summary judgment hearing with respect to this?
There was a summary judgment hearing on the...
Was this motion noticed for hearing at that hearing?
Your Honor, I really don't remember. I don't remember. I remember going at some hearings, and the problem is all the hearings were consolidated, and very often we'd have like 6 or 7 things, along with Faith Horn and Keating's lawyers were there, and a lot of times we dealt with 3 or 4 motions with the time we had.
But I guess that's not an issue raised either, the procedural issue.
No, I didn't raise it procedurally.
Mr. Egan, let me ask you a question, sir. You made the assertion that the appearance by the attorney in the media was incidental to the accomplishment of the client's purpose, right? Is that your contention?
That's the appearance of things.
Just let's say that, just for the sake of argument, that we disagree with you on that we don't think it's incidental. Do you lose at that point, or do you still have an alternative argument?
No, one of the things about summary judgment is there's a burden of proof, and somebody has to carry it when they file the motion, and they have to dispose of certain facts. We had alleged in our complaint that he in fact acted as an agent.
He what?
He acted as an agent in Wausau when he made those statements, and they authorized it. That has to be disproven. If you're going to go for summary judgment on that, that's our allegation.
Are you saying that you have two theories of agency, one of apparent agency and one of actual agency?
Well, our argument that there was an actual agency, I'm not talking about the legal concept of apparent agency.
That he was expressly authorized by the principal to make the appearance on television.
We had alleged that on our complaint.
And you alleged it.
But he acted on their behalf at their direction.
And they didn't negate it through any...
They didn't negate it. They didn't withdraw it.
Was there any was there any depositions in the record or anything, any record evidence at all?
There was Mr. Talmadge. We took his deposition in the criminal case. There was no deposition by him in the civil case. There was no affidavit filed on behalf of the lawsuit.
So the trial judge granted summary judgment based on the 4 corners of your complaint. So you would have had to have pled yourself out of court in order for summary to be proper. Is that what you're saying?
I'm not sure what you mean.
Did the trial court consider anything extrinsic to your complaint in granting summary here?
Well, if you look at the findings of fact, Your Honor, there was maybe 20 or 30 depositions in all the cases, the 924 cases, the Faith Horn and Keating cases. There was a wealth of them as to whether or not Wausau, in fact, directed, told, advised, whatever communication, whatever payment, whatever records between Wausau and Spangler, there was no discovery whatsoever about that, and none was ever allowed. I mean, it was my feeling, and I'm still of this mind, that summary judgment without an affidavit, it doesn't work.
Well, the rule specifically says that you can move for summary judgment with
Absolutely.
or without affidavit.
Absolutely. You can rule on motion, your request for admissions. I had submitted a request for admissions that they had authorized, approved, or paid for. Spangler, they refused to either admit or deny, claiming that that's a matter of privilege. It was never addressed, nor could it be addressed. Judge Thorpe would not allow discovery in that matter. But yet she ruled, I mean, the alternative is, I guess if they would have filed an affidavit saying, we never told them, we never authorized, of course they would be waiving their privilege, which
Well,
they...
this is an issue on which you would have the burden of proof at trial,
We
correct?
would.
Okay. And the summary judgment procedure doesn't shift the burden of proof, does it? I mean, that the movement has the burden of establishing that there's no genuine issue of material fact, but, I mean, does that necessarily... I don't see that as shifting the-
Summary judgment is not a trial.
I mean, you're arguing that they had to disprove an agency in order to win summary judgment. And I don't, that
They have to disprove every allegation of material fact in my complaint. That's their burden. At trial, I
where does
didn't
it say
carry
that?
that burden, huh?
What's the authority for that proposition?
Because in the allegation, the elements of the cause of action, they are alleged, they are the material facts that are at issue. They have to be disproven. If I allege he owes $80,000, that has to be disproven. At trial, I still have to prove he owes $80,000, but I don't have the burden of proving that till I go to trial. The function of summary judgment is to cut off my opportunity to go to trial by saying, that's not an issue, we can disprove it right now on the basis of this affidavit. That's not an issue. I get it, a litigant gets an opportunity to go to trial unless something stops them. And the only way a defendant can stop a litigant from going to trial is by, exercising from the case all issues of material fact. We had alleged an agency relationship. It's up to, they have that burden prior to trial of disproving it, or overcoming it, or saying this is not an issue. The mere fact that the judge thinks that this is incidental, or this is not incidental, or this was something that he thought of entirely on his own, that's not based on any facts. That's not based on anything that she got from any deposition of
You want to say
WASSAU.
some rebuttal time, Mr. Egan? You got about 3 minutes left.
All right, I'll reserve. Thank you.
May it please the court, Antonio Moring from the law firm of Ackerman Centerfit on behalf of the appellee, in this case, Wausau Insurance Company. As this court is aware, there are two main issues raised in our brief, the first of which is the one which the trial court granted summary judgment in Wausau's favor on, and this is the issue of agency.
Well, from looking at the transcript, the complaint was brief, short, and it laid out specific things that it is alleged the agent said on behalf of the company. From the record, we know that there was a long-term history of the lawyer being involved with the witnesses in this case. The judge, by citing to the Lipsick case, said, based on what I reviewed, there was no affidavit. Did the judge use depositions from other cases in assisting her in making the decision?
Well, there were depositions that were filed in consolidated cases.
I understand, but did the judge use those in making the decision to deny the motion for summary judgment?
Quite frankly, in her order itself,
Yes,
I don't believe it references depositions in other cases. It may reference earlier testimony from Louise Rothstein in terms of providing a background for what transpired in this case, but I don't believe, as a matter of fact, there are depositions specifically referenced when it comes to the issue here in the defamation case that reference to that deposition.
Here's what troubles me. With that being an unknown, there being no affidavit, there being specific allegations in the complaint that said this proves defamation and this proves that he was working for the company at the time, What basis then did the judge have to truncate discovery or not let the case go on when at least on the face of the pleadings, they established the elements of defamation and agency?
Well, I think something has to be cleared up here. There was no issue of truncated discovery before summary judgment was granted here. While there was a wealth of deposition that took place before this case was even initiated, there were depositions of Mr. Spangler, there were depositions
Were
of
they
KERRY.
related as to the defamation?
Yes.
And were they reviewed by the trial court?
Well, they were filed. There was notices of filing.
My question. For example, did you say, look to deposition A, B, page 2, look to deposition 3, 4, 5? Or did the judge say, I read it and that's why I'm making this
In
decision?
other words, how did you meet your burden under the summary judgment rule of showing or demonstrating to the trial court that there was no issue of material fact as to the issue of agency?
Well, our burden was met in the sense that, and I guess let me start from the beginning in saying that the legal test we outlined for the court was under the Lipzig case, which you've referenced, which is to say to the court, look, the test here is they've alleged an agency on the part of Mark Spangler and WASSAU, Mark Spangler being the agent, quote unquote, of WASSAU as its attorney in the workers' compensation litigation.
Well, let me give you another. Say that the issue was whether your client was liable under the vicarious liability theory because they owned a car that was involved in the accident, although they weren't a driver. The complaint says Joe Smith, your client, owns the vehicle and is therefore vicariously liable for the action of the driver. Okay. And typically, normally, if you were going to move for summary judgment, you'd file the affidavit of Joe Smith saying, I don't know the car. And then the other side would have the opportunity to come forward with any evidence that shows that there's an issue as to that point. Now, would it be sufficient for you to simply file a motion that says there's no issue on the, I mean, does the other party even have to respond with affidavits if you don't do anything except say in a bare bones motion, there's no issue of fact, I don't own, because my client doesn't own the car, without any evidentiary support anywhere for that old?
While it certainly is our burden we have to meet our burden for summary judgment, I think what needs to be...
The question is, what did you do to meet that burden?
Well,
There are no affidavits?
Well, I think we met the burden by simply saying, court, here's the standard by which you have to determine whether they've created an issue of material fact.
Counsel, you had to conclusively negate their allegation that he was an agent of WASSAU. You had to conclusively negate, that's a statement of fact that he was an agent. You had to conclusively negate that. Now, you could have done it by filing an affidavit from an authorized officer of your company saying, we never authorized him to do it. He was acting on his own when he did this. He wasn't acting as our agent. He didn't have actual authority to do that. You could have done that, and then they would have had the burden to come and file a counter affidavit that would have created an issue of fact. But you didn't do that. So is there any place in the record, in the depositions that you've referenced, where you did essentially the same thing, where some witness testified on behalf of WASSAU that the attorney was not acting as their agent in fact?
Was there direct, I guess to first address the last question, there was no direct testimony cited to by WASSAU saying, Mr. Spangler said, WASSAU did not authorize me to make these statements.
All right, then you want to tell us about the, is it Lipzig case. Now, the Lipzig case was a trial, right? There had been a trial.
There had been a trial, it was a 50-day trial, and there was a jury verdict entered in favor of the...
And there was evidence in the record in Lipzig that the attorney wasn't, didn't have actual authority, and the plaintiffs in that case was arguing that merely by virtue of his status as an attorney, he had the authority to bind the client to these defamatory statements, right?
Well, there was testimony, it's unclear what the nature of the testimony was in terms of the extent of the lawyer's authority. The reason and I think the point in Lipzig is what the legal test is to be used to determine whether you can hold a client vicariously liable for the allegedly defamatory statements of an attorney.
Well, there has to be, the legal test you talk about is whether there's essentially actual or apparent authority.
And I think the issue is then, well, if you're dealing with, let's say, what's called apparent authority for purposes of argument.
Let's just deal with actual just for a minute, all right? How do we know that WASSAU didn't direct the attorney to make the statements on TV?
Well, I think I'm gonna have the fundamental disagreement with the premise that we have the burden to disprove, in essence,
Well, you
an
have the
unfounded
burden, you
allegation.
have the burden to disprove the allegations in the pleading.
But for purposes of summary judgment, a plaintiff cannot sit behind unsubstantiated allegations to say, I've met.
Well, the problem is this, you've got a complaint that outlines what the theory of the case is and the basis for recovery. On a motion for summary judgment, you can't just come in and say, we think that's wrong, or we don't think there's any proof, and the judge says, okay, and then you go your merry way. You've got to give access to the courts, and you've got to show or negate or disprove by deposition, affidavit, or reference to deposition in another case so that the judge could see why there is no authority. My question to you earlier was there a deposition filed, were the depositions reviewed, or did you notice to the court page and number that would support your theory?
What we know.
And you don't know if the judge read those other depositions or not.
What we noticed to the court was the fact that there was absolutely no record evidence, no evidence in the record by virtue of deposition of any kind whatsoever that were filed in the consolidated cases, I may add.
What duty does a litigant have to put evidence supporting their complaint in discovery so that you can find it there? I mean, that they would have a burden at trial to put forth their evidence, but you can't just say, well, we've done discovery and they haven't given us in discovery, none of their witnesses. I'm just not following.
Well, in the frame, in the posture of a summary judgment motion, and in the legal argument re-raised regarding the scope, or in this case, we're talking about, Spangler's actual authority, and our argument that there was absolutely no record evidence our point is on summary judgment, after all the depositions have been taken, after all the evidence has been adduced, it's well within our right to point to the court on summary judgment and say there's absolutely no record evidence to substantiate the allegation.
I agree with you, but the question is, how do you convey that to the court? The court, you can say, here's an affidavit, here's a deposition, here are portions of a deposition, but there's nothing there. I mean, to say, well, judge by osmosis, you can look and be our lawyer and find out, it makes no sense. It's your obligation to point the court to proof in the record or records why the statements made in the complaint are not true or can be rebutted by statements from depositions or by an affidavit.
I believe we pointed to court to the absence of any evidence in the
Okay.
record of the fact.
How did you do that? Can you direct me to a pleading that you filed, notice that you gave to the parties, or depositions that you attached and said, here is information under oath, or here's information from us and an affidavit under oath that refutes the elements of his complaint?
There was no affidavit filed that said to the court, under oath, there's no record evidence to support any allegation that there's actual authority or Spangler was acting with actual authority.
Did you ever ask that the complaint be dismissed because it was improperly pled, or that the complaint sought relief that was not allowed under Florida law?
No, there was a separate issue that was addressed regarding a motion to dismiss because of failure with respect to service of process.
Right.
There was no independent motion to dismiss arguing that they failed to state a legal claim because obviously they had asserted allegations indicating that,
So
Spangler was acting.
the complaint, in your opinion, was valid on its face?
On its face, it wasn't subject to a motion to dismiss for failure to state a claim.
Okay.
I don't think, however, that converts it then to say that we were not entitled to summary judgment. I think the point that we made and the point that we relied upon and we cited to the court was simply, look, Spangler's deposition has been taken, KERRY and Barney DREGGORS' deposition has been taken. Everybody involved, potentially involved with these allegedly defamatory statements, deposition has been taken, and there's not one single shred of evidence in the record before the court to support any allegation whatsoever that WASSAU actually directed Spangler to make these statements. To the contrary, then our argument was, under Lipsig, if you look under, what they'd have to rely on, which is essentially apparent authority, they're going to have to argue that by the very nature of the act, it was necessary or incidental, and the court ruled as a matter of law, it was not.
The problem for me is this: you had different cases trying to do different things, different questions being asked in depositions to support that particular case. So to say to the judge on the issue of defamation, if you look in the criminal case, if you look in the civil case, you can glean that he was not our agent, when in fact there was a finding in other cases that he was. You sort of lost me.
No, while there was depositions, the cases were consolidated for purposes of discovery. So For instance, in the deposition of Mark Spangler, there was deposition question directed to issues regarding the taping cases.
Right.
But there were certainly deposition questions and discovery related to the defamation cases, and in fact, he was questioned about the statements made during the television news broadcast and so on and so forth. So that this discovery in these cases, in these 6 cases, actually 7 cases in total, that went forward, went together on a consolidated basis, and there was discovery on both ends of the spectrum at every turn.
One final question from me. Can you document or can you allege or state that the judge saw those depositions and from those depositions determined that the motion for summary judgment should be granted?
Based on the sort of routine language in her order regarding her review of the record, I can only assume that she actually referred to Spangler's depositions and the other depositions that had been on file in the case to determine whether in fact there was no record evidence, which I think is undisputed on this point, to suggest that WASSAU actually directed Spangler or authorized Spangler to make these allegedly defamatory statements on the television news broadcast.
Let me go at it this way. Rule 1.510C, in talking about the movement's burden and what they have to do in a motion for summary judgment, states that the motion shall specifically identify any affidavits, answers to interrogatories, and admissions, depositions, and other materials that would be admissible in evidence, and calls that the summary judgment evidence on which the movement relies. And I guess the trouble that, I think the problem we're all having is that if you don't do that and you haven't told us how you've done that, then why does, if you haven't met your burden by presenting some summary judgment evidence in the form that it states that you need to in the motion, why does the other side have to respond or do anything?
I think, from our perspective, an argument is simply this, that as a defendant, you have the ability to file a motion for summary judgment where your argument is based on the complete lack of any record evidence to support basically what is an unsubstantiated allegation. And at that point, of course, any litigant, any plaintiff can come around and say to the court, well, we haven't had the opportunity to take this discovery that would establish.
Your position that all a defendant needs to do is come in on any issue and say, for example, Judge, this is a standard for negligence, and we don't think there's enough evidence to show it, and that's all you have to do, that's your motion for summary judgment, and then it's granted unless the other side comes in with whatever evidence it would present at trial to show that they can meet their burden on that issue. Well, that seems to be the argument you make.
Our summary judgment, our position is it's his burden.
Sure makes it quick. You don't have to do any discovery that way.
Well, I mean, and that's not the point here. I mean, the point is that they, first of all, this case over, I want to say it's more like 5 years before this actually went to summary judgment, and there was discovery on these cases for maybe 2 or 3 of those years.
There's no 5-year exception, counsel.
No, and that's, I understand, Your Honor. But quite frankly, I don't believe then the rule of law is either that a plaintiff can stand behind unsubstantiated allegations to defeat summary judgment and simply say to the court, because I've alleged it, although there's absolutely nothing in the record to support it, I have absolutely no evidence I'm going to be able ever to present to the court to stay what I'm saying in my complaint, I can defeat summary judgment.
He attached a transcript of the interview.
That is correct.
And if the case has been going on for 4 or 5 years, I would assume that there's an index to the depositions and what was said, who said it, who asked it. And it strikes me that it would be very simple to either attach copies of those pages or give the judge a sheet stating here's where they can be found to support our motion for summary judgment. And if you look at the record, there's absolutely nothing there, and there's nothing in the judge's order that says I reviewed the depositions of, or the deposition was presented, etc. I mean, it's just, there's nothing there.
Well, for purposes of the way this case sort of transpired, in essence, you'd be asking us to file a motion telling the court, we refer to the court to all the depositions taken in this case, any single shred of discovery taken in this case.
Maybe file a motion with an affidavit from someone saying that
I've reviewed the record.
He was not acting as our agent?
Well, that's a separate issue regarding attorney-client privilege, and our argument still remains today that, and I think it's consistent with Florida law, is that you cannot compel waiver of an attorney-client privilege by asserting a claim. In essence, this is not an issue where we've asserted a claim and then we're trying to hide behind the privilege. Our argument was simply this. It's his burden, and this was the standard he had to prove. He had to prove, was it necessary or incidental to the representation? If he can't do that, then he has to show as a parent it was actual authority that was at issue here. He can't do either of those things. It's not our burden to help him prove his case. We can assert our privilege, and it's unfortunate if Mr. Egan and his clients then cannot prove their case, but they cannot compel the waiver of an attorney-client privilege based.
How is it that whether or not someone is representing a client at a certain time is an issue of privilege in general, in a civil context?
Well, the issue that was being raised was communications between Wausau, arguably, and Spangler during the relevant time period. So there was assertions of privilege, and there was, wide issues regarding privilege in this consolidated case because there was more than one issue involved.
There was never a dispute that he worked for Wausau. The question was, the statements he made, was it in the discharge of his duties in representing his client?
Yes. And our argument was, as a matter of law, it wasn't necessary.
How is it privileged? I mean, whether Wausau paid him for the time spent during that interview, how is that privileged? How is that attorney-client?
Well, at one point, first of all, we would argue that the time descriptions would actually be attorney-client privilege depending on the content of the descriptions. Now, that issue wasn't
Generally, that's not,
Well, it's
communication for legal advice or the giving of legal advice. I mean, generally.
depending on the content of the actual description. I agree with you. It depends on the
Did the
content.
trial judge do an in-camera inspection to determine whether?
There were, I don't remember an in-camera inspection based on any motion to compel filed by Mr. Egan, specifically arguing about billing records. One thing I would point out, though, is that during Mark Spangler's deposition, he was actually asked specific questions regarding any sort of authority, not any authority by Wausau, but any sort of billing issues. Were you billing Wausau for your time during, this sort of broadcasting of these defamation statements and so on and so forth? And basically Spangler sort of denied those issues. And I'd only point this out because this is a little bit different than the Keating case, although we disagree with what the court did in that case, where it basically said there was an issue of material fact regarding the agency,
Right.
because there was record evidence that Spangler testified that he would bill Wausau presumably for the time spent in investigating the case.
Which is one of the things that brings us to why oral argument was perhaps not needed. If you have a case that was issued recently by this court dealing with agency, what is it that you want us now to do in this particular case where agency is an issue?
Well, I think the distinction here was, first of all, under the Lipsick case, we have a fairly firm test in terms of applying to the defamation case. Second of all, as opposed to the Keating case, again, where you had record evidence and you were citing to record evidence, again, we disagree with the conclusion, but you have record evidence that Spangler testified that he arguably billed Wausau for his time spent in investigating or in contacting Louise Rothstein, and the court essentially ruled that based on that, you can essentially infer, or a jury could infer, issues regarding agency or the authority given to Spangler. In this case, there was no such evidence because Spangler, in fact, testified that he rejected that sort of implication when he was directly asked in his deposition. So, as opposed to the Keating case where you had that record evidence from which the court, again, we disagree with it, but which the court could essentially argue there's an inference to be drawn, in this case there is no such inference. Secondly...
But isn't the evidence the same in all of these cases because they were consolidated?
Well, the evidence is the same in the sense that all the evidence was gathered in the course of these 6 cases, but in terms of what is the relevant evidence to determine whether he had authority regarding a defamatory statement or authority regarding contacting a witness to determine whether she provided attendant care are 2 entirely separate issues, as we see it. In addition, the other reason why we requested oral argument was because we raised a second point that is completely distinct from the agency issue, which is the issue regarding pure opinion. And it was an issue raised at the trial court, and an issue which, I'm running out of time here, but an issue which we believe...
No, you're over time. You're out of time.
Okay, well, I apologize for that.
Sure.
If I may briefly conclude...
Well, you can conclude in about 10 seconds.
Okay, we respectfully request that the court affirm summary judgment. We believe we're entitled to summary judgment either on the issue of agency, which the court ruled upon, or on the question of pure opinion, which was briefed in our papers.
Thank you, sir.
Thank you, sir.
All right, thank you, Mr. Egan.